Peace, peace, peace. It is Empress ShayMarie back with another recording on this lovely moon day, October the 10th, 2022. Hope everyone has been having a lovely day. I want to thank you for taking the time to listen to this recording. If you are having the luxury of doing so, I just want to thank you. And today I'm going to be starting a brand new book. Been over the last few weeks going over a lot of information in regards to trust, and actually been reviewing this book and very, very, very impressed with all of the amazing information that is in this particular book. Um, if you've been following my channel, there's a lot of information I put on there about, the straw man and you, using common law and commercial law. And we've talked about a trust, put videos about expressing the trust and things of that nature, just doing different readings. Um, and over my course of, I will say, 3 to 4 years of research, um, within the last year, maybe a last year and a half, is more so when it started becoming obvious to me that there was a particular trust and that we would be able to have access to this trust, or being able to utilize this trust, or taking control of this particular trust. So I'll say about a year ago, I started hearing about express the trust, express the trust. And so that's when I dropped that express the trust video on my page. But I've been hearing it a lot more lately. And I've always wondered, like, okay, we know that this trust exists. And what frustrates me is I hear a lot of people saying to get an LLC, you need to go form a trust. You need to, why do I need to do, my question has been sometimes, why do I need to do all of these other things when I need to learn the foundation of how this particular trust that exists, that everyone's claiming is existing, how to operate underneath that particular trust and utilize that trust that is already in existence. That is the foundation of everything. Instead of creating other trusts, and I'm not too really sure if all of those things are or have been necessary, which has been a lot of the main reason why I have not done a lot of these different procedures and remedies and things that you have all of these different gurus and people out here sharing. Um, so I wanted to come and do this video. I wanted to come and read this book. It's been very interesting getting familiar with this book. So I wanted to read it in its entirety, and I wanted to record myself reading it so that I can be able to come back and hear it being read. That way, um, I can play it when I'm doing other things, or reading along with it. It just helps me to comprehend the words that are in the books a little bit more. So I'm going to begin on the coming up here, this capsule summary. Okay, so it'll be about the first 35 pages, first 37 pages of the book that I'll be going through. And that'll be this recording, and then I'll come back for the next recording. So with that being said, I hope you appreciate the information that was shared here. And if you'd like to make a donation, feel free to do so by sending a Cash App donation to my Cash App, or I have CHIME, and the information can be found in the description area below this video if you're currently watching. Okay, so we're at the introduction of the capsule summary, and we're talking about trust, okay? It says definition of fundamental terms. Number one is trust. Trust. A trust is a fiduciary relationship with respect to specific property to which the trustee holds legal title for the benefit of beneficiaries who hold equitable title. Okay, so I kind of like to educate as I go along in my readings so that we can um, know what is being said here. Okay, so I want to look up equitable title. Okay, so we're at the Black's Law. This is the fourth edition, Black's Law Dictionary, fourth edition, and I'm looking up equitable title. Okay. Looking up the actual word for equitable title. Okay. Okay, so equitable title doesn't look like it has an actual definition itself, but here under equity, um, let's look up equity first. This is gonna have a long long definition, I'm sure. Okay, did we pass it? Did we pass it? Equitable rule, equitable right, equitable jurisdiction. Okay, let's see what this is. It says perfect equity, an equitable title or right which lacks nothing to its completeness as a legal title or right except the formal conveyance or other investiture which would make it incognizable at law. I'm sorry, make it cognizable at law. Perfectly the equity or interest of a purchaser of real estate, who has paid the purchase price in full and fulfilled all conditions resting owe him, but has not yet received a deed or patent. Okay. So it's equitable title, but haven't received the deed or patent. Okay. So it's almost like an interest. Okay. All right. Going back to the book, it says, um, a settler. A settler is a person who creates the trust by will or inter vivos transfer. The settler may also be called the trustor, donor, transferor, or grantor, or testator. 3. Trustee. The trustee is the individual or entity that holds legal title to the property. Number 4, trust property. The trust property or trust res is the interest the trustee holds for the beneficiary. Number 5, a beneficiary or cestq trust is a person for whose benefit the trust property is held by the trustee. Classifications of trust. Number 1, methods of classifying. Trust may be classified according to the duties. Number 1, imposed on the trustee, i.e. active versus passive, or number 2, purposes of the trust, i.e. private versus charitable. Number 3, manner of creation, such as express, resulting, or constructive. And number 4, time of creation, i.e. inter vivos or testamentary. Active versus passive trust. In an active trust, the trustee has some affirmative management duty. In a passive trust, the trustee has no real duties but is a mere holder of legal title. A. Statutes of uses. Uses were historical predecessors of trust and were usually passive. The Statute of Uses was enacted in 1536 to eliminate this method of holding or passing title to land. The statute transformed an equitable interest into a legal interest. The statute, as construed, was held inapplicable to some uses, such as personal property, or most active uses were not covered. The statute of uses concept is still recognized in most American jurisdictions. Private versus charitable trust. A charitable trust bestows a benefit upon the public at large or upon broad segment of the public. Other trusts are private and are subject to more restrictive rules. Expressive trust versus those created by operation of law. An express trust is created as a result of a manifestation of intention to create the relationship that the law recognizes as a trust. B. Resulting trust. A resulting trust is an equitable reversionary interest based on the legally presumed intention of a property owner. It arises by operation of law where an express trust fails in whole or in part, or where its beneficial provisions are incomplete. C. Constructive trust. A constructive trust is a remedial device imposed by a court of equity to prevent a person who has obtained property by wrongful conduct or unjust enrichment from deriving the benefits thereof. C. Trust distinguished from similar relationships. Number 1. Characteristics, not terminology controlling. Other legal relationships may resemble trust but lack one or more trust elements. Number 2. Bailment, where an owner of tangible permanent property gives possession of the chattel but not title to another, the relationship is a bailment. A bailment differs from a trust in that it applies only in chattels. B. Both legal and equitable title remain in the bailor. C. A bailee cannot convey title. D. Rents, profits, etc. belong to the bailor as opposed to a beneficiary in a trust relationship. And E. Bailment remedies are usually legal, while trust remedies are equitable. Pretty much the difference between private versus public, or public versus private. Bailment bailment keeps you in the public, and trust remedies are equitable, which keeps you in the private. Agency, number 3. An agent is a fiduciary with many responsibilities similar to those of a trustee, but an agency differs from a trust in that A. Holding title to the property is not an essential aspect of the agency. B. The agent is subject to control by the principal. C. The agent's authority is strictly construed. And D. The agent acting within the scope of authority is not personally liable, while a trustee is liable to third parties for acts on behalf of the trust. And E. The agency terminates upon the death or traditionally incapacity of the principal. Number 4. Debtor versus or debtor-creditor relationship. Although a creditor has a claim against the debtor, an unsecured creditor has no interest in specific funds or property. The crucial distinction between this type of relationship and a trust is usually whether the parties intended to create a relationship with regard to specific property. Note that payment of interest is virtually conclusive that the relationship involves a debt. The holder of an equitable charge 5. Equitable charge. The holder of an equitable charge has a mere encumbrance or lien against property, while a trust beneficiary has equitable ownership. Such a distinction is important regarding the right to income. There is no fiduciary relationship in an equitable charge. 6. Conditional fee. A conditional or a condition in a grant for the benefit of the grantor or a third party may at times suggest a trust relationship, but also may be construed as a trust, an equitable charge, or a conditional fee, because failure of the condition terminates a conditional fee estate. Courts usually favor construing conditional language as a trust. Number 7, other relationships. Other fiduciary relationships, such as guardianships, may appear similar to trust, but they differ in one or more key aspects. Number 2, elements of a trust. A. Introduction. The usual elements of a trust are 1. Trust intent. 2. Specific trust res. 3. Property or properly designated parties. And 4. A valid trust purpose. Consideration is not required. B. Expression of trust intent. Express trust. Number 1. In general, the settler must objectively manifest a final, definite, and specific intention that a trust should immediately arise with respect to some particular property. 2. Form of expression. Manifestation of intent may be by word or conduct. Some external manifestation is required, but no specific word need be used, and words of trust need not be construed as creating a trust. The settler's failure to communicate intent to beneficiaries will not prevent a trust from arising. Precatory expressions of intent. Precatory language of the settler. I wish, I hope, etc. presumptively does not create a trust under the modern view. However, such language may be construed as creating a trust in light of other factors such as A. Detailed instructions to an alleged trustee. B. Language addressed to a fiduciary. C. An unnatural disposition of property resulting if no trust. C. Timing and placing of precatory terms. And E. Pre-existing relationship between the parties or other expressions of the settler that would seem to indicate a trust relationship was intended. 4. Time when the trust intent must be expressed. The general rule is that the intention to create a trust must exist and be manifested at a time when the settler owns or is transferring the rest. A. Gifts. The owner may not convey property as an outright gift and later convert the gift into a trust. B. After acquired property, where a voluntary trust intent is manifested prior to acquisition of the property to be put in trust, courts will usually find sufficient trust intent if there is some other or further manifestation of such intent after the property is acquired and consistent with the prior expression. 5. Trust must be intended to take effect immediately. The settler must intend that the trust take effect immediately, even if subject to revocation, and not at some future time. Subsequent action. If there is an appropriate subsequent act, such as a transfer, consistent with the previous stated intent coupled with an intent that the trust presently take effect, a valid trust will then arise. B. Effect of postponing designation of essential elements. If the settlor purports to create a trust but postpones designating the beneficiaries, trustee, or the trust res, the incomplete terms of the trust indicate that a trust is intended to arise in the future. There is no valid present trust. C. Trust of future interests and promises. A future interest may be the proper res of a present valid trust, as may an enforceable promissory note. 1. Effective consideration. Although an unenforceable promise to create a trust in the future does not create a trust, and if consideration was given for an otherwise enforceable promise, the intended beneficiaries' rights can be enforced. D. Savings, banks, or bank trust, or totem trust. These are generally held to be valid, revocable, inter vivos trust. E. Testamentary trust. Trust created by will meet the immediate effect requirement because the trust intent is expressed at the time the will speaks, i.e. at the testator's death. C. Trust property res. 1. Requirements. In general, the res must be 1. An existing interest in property, 2. Capable of ownership, and 3. And usually of alienation, and 3. Sufficiently identifiable or identified. Number 2, interest in property. The res must be an existing interest in existing property. A. Mere expectancy. A mere expectancy, i.e., an interest that has not yet come into existence, is insufficient. If consideration is involved, the courts may find a contract to create a trust, or if the property is later acquired and the settlor then remanifests an intent to create a trust will come into existence at that time. B. Equitable interest. Equitable interest, such as the interest of a trust beneficiary, if assignable, may constitute a trust res. 3. Alienability. In general, the interest to be placed in trust must be alienable, as trusts are created by some form of transfer. At early common law, some future interests were not alienable and could not be transferred into a trust. This is no longer true in most jurisdictions. Certain other types of property, such as tort causes of action, are frequently held to be personal to the holder and thus may not be transferred. 4. Identified or identifiable. The trust res must be specific property that is actually identified or described with sufficient certainty that it is identifiable, such as can be ascertained from existing facts. A. Fractional interest. Fractional interest in specific properties may be the res of a trust. B. Fungible goods. Some doubt may still exist where a trust is sought to be created in a portion of fungible goods, such as cash, commercially equivalent goods, but this should not be a problem if the broader collection is itself identifiable. C. Obligor as trustee. Generally, when a person makes an agreement with his creditor to pay a third person, he does not become a trustee of what is simply his own debt, as there is no identifiable res. Obligee as trustee. A bank is not normally a trustee of unsegregated funds, but a bank depositor, the obligee, may hold or transfer the deposit, i.e., debt, in trust for another. The deposit, a choice in action, is an identifiable res. Properties for the trust or properties to the trust. Settler 1, or trustor. Generally, a property owner may create a trust of that property and become a settler. A. Capacity. The settler's legal capacity to create a trust is measured by the same standards applied to similar non-trust conveyance, such as legal age and sound mind. B. Rights in trust property after creation of trust. Once the trust is established, the settler generally has only such rights or interests in the trust property as reserved by the trust terms or as are not disposed of by the trust terms reversionary interests. But a growing number of states provide that trusts are revocable unless expressly declared to be irrevocable. A trust may, however, be set aside or reformed in case of fraud, duress, undue influence, or mistake. A settler who retains no powers or beneficial interests is usually held to have no right to enforce the trust. C. Settlers' creditors. The settler's creditors may reach retained beneficial interests. Despite this, the traditional but declining view is that creditors may not reach the corpus of a revocable trust unless its creation was a fraud upon creditors. Number 2, trustee. The trustee must have capacity to take and hold title. At common law, partners were precluded from being trustees, but this is no longer the case. Corporations may be trustees, but several states limit or condition the ability of foreign corporations, i.e., those incorporated in other states, to engage in trust administration. Note, the constitutionality of some of these statutes is questionable. To continue serving as trustee, the designated trustee must also have capacity to administer the trust. Each co-trustee must have the requisite qualifications. A. Bonding. Many states require trustees of testamentary trusts to post faithful performance bonds. B. Failure to name trustee or failure of named trustee to serve. If the settler fails to name a trustee or the named trustee fails to survive or qualify, where the trust is otherwise validly created, equity will not allow a trust to fail or for lack of a trustee. A court will appoint a trustee to save the trust, except in rare cases where the settler clearly manifests intent that the named trustee is the only acceptable trustee. However, the absence of a trustee may cause an intended inter vivos trust to fail for lack of effective transfer. Trustee disqualified. If the trustee is technically disqualified by law from taking title initially, there is a split of opinion as to whether courts should salvage an inter vivos trust despite the apparent defect in the intended transfer for lack of a transferee. In testamentary trust, this problem does not exist. Nature of trustee's interest. The trustee generally is said to have bare, bare legal title, i.e., devoid of beneficial ownership, holding property for beneficiaries in accordance with the trust. The trustee of an inter vivos trust derives title from the trust instrument. Courts are split on whether a testamentary trustee derives title from the will or by the judicial appointment that confirms the nomination in the will, with the title relating back to the settler's death. The trust instrument usually spells out the nature and extent of title conveyed to the trustee. If there is no trust instrument, the court will determine the quantum of the estate. In such cases, the trustee traditionally takes title to real property only to the extent necessary to carry out the trust. But today, this normally requires full title. 1. Trust estate not liable for trustee's personal debt. The trustee's personal creditors cannot satisfy their claims from trust property. 2. Effect of trustee's death. If the sole trustee dies, title to the trust res is held to pass to his estate subject to the trust. The court will then transfer title to a successor trustee. Co-trustees are presumed to hold as joint tenants with right of survivorship unless the needs of sound administration or the terms of the trust indicate that a successor trustee should be appointed. The court will allow the surviving trustees or trustee to serve alone. D. Disclaimer or resignation by trustee. 1. Disclaimer. A trust cannot be forced upon a designated trustee who has not previously accepted the trust or contracted in advance to do so. With some exception, a trustee cannot accept in part and disclaim in part. Resignation. A trustee may not resign unless the trust terms give him the right to do so or all beneficiaries consent. A trustee must obtain a court order relieving him of his duties. Removal of a trust. E. Unless a trust instrument states otherwise, only a court of competent jurisdiction has the power to remove a trustee. Animosity between the trustee and beneficiaries is not in and of itself a sufficient ground for the removal of a trustee unless it jeopardizes the trust. Note, courts are less willing to remove a settler-appointed trustee than a court-appointed trustee. 1. Removal by beneficiaries. If the trust terms allow the beneficiaries to modify or terminate the trust, they have the power to remove the trustee. F. Merger of title. Where a sole trustee and a sole beneficiary are one and the same person, the result is a merger of title and equitable titles, defeating the trust and creating a fee simple in the person. Interest must be exactly the same for merger to occur. 3. Beneficiaries. Necessity of beneficiaries. 1. Private trust. To create a private trust, a settler must name or otherwise describe as a beneficiary one or more persons who are or will become capable of taking a property interest and becoming an obligee. Without a beneficiary, there is no one capable of enforcing a trust, and therefore it will fail. A trustee need not know who the beneficiary is as long as the beneficiary is identifiable or will become ascertainable within the period of the rule against perpetuities. Infra, if the private trust fails for lack of a beneficiary, there is a resulting trust in favor of the transferor. 2. Charitable trust. Identifiable beneficiaries are not required for charitable trust. Honorary trust. Many jurisdictions allow the voluntary carrying out, but usually not enforcement of some trusts that are regular or that are neither charitable nor private, such as for care of a person's pet or for some other non-charitable purpose. Some jurisdictions prevent such honorary trusts from being implemented even voluntarily by the transferee with a resulting trust for the transferor, his estate, or his successors and interests. B. Who may be a beneficiary? Generally, any person, natural or artificial, who is capable of taking and holding title to property may be a beneficiary of a private trust. This includes minors and incompetents, and under modern law, unincorporated associations. Trust for the continuing benefit of non-charitable unincorporated associations may fail because of the rule against perpetuities. C. Incidental benefits. Not every party who stands to benefit by operation of the trust is a beneficiary. one whose benefits are only incidental is not a beneficiary and cannot enforce rights under the trust, such as where trust terms require investment in a particular corporation. The corporation is not a beneficiary. D. Reasonably definite class requirement. Beneficiaries must be ascertained or ascertainable when the trust is created or become ascertainable within the period of the rule against perpetuities. Thus, persons must be identifiable as beneficiaries or members of a reasonably definite or ascertainable class. The beneficiaries need not be ascertainable at the time the trust is created, but the instrument must then provide a formula or description by which the beneficiaries can be identified at the time when their enjoyment of interest is to begin. That time must be within the perpetuities period. Number one, statute or status until beneficiaries ascertained. A few classes have held that there is no trust if all beneficiaries are presently unascertained. The majority view is contra, provided the beneficiaries will be ascertained within the period of rule against perpetuities. Until the beneficiaries are ascertained, there is a resulting trust for the benefit of the settlor, subject to an executory limitation in favor of the beneficiaries. A. Heirs of settlers. In most jurisdictions today, a remainder to the settler's heirs is enforceable. In the few jurisdictions that still follow the doctrine of worthier title, there is a reversion in the settler. An analogous problem arises in those few jurisdictions adhering to the rule in Shelley's case. 2. Caution. Formalities must be satisfied. Whatever requirements are applicable must be followed in the instrument identifying the beneficiaries, i.e., testamentary trust must meet the requirements of the statutes of wills, and inter vivos trust must meet any applicable requirements of the statute of frauds. 3. Class gifts. Trusts for the benefit of a class of persons are valid, provided the class membership, as described, is or will become reasonably definite and ascertainable within the period of rule against perpetuities. A trustee can have the power to select among members of a class if the class is sufficiently definite. If not, under the traditional view, such power does not make the beneficiary sufficiently ascertainable to validate a trust. If, however, the power can be exercised in favor of the trustee, although other class members are indefinite, the court will probably treat the trust as an outright gift to the trustee, a reasonably definite class. The class of beneficiaries must be definite enough for a court to determine by whom or on whose behalf the trust may be enforced, and where the trustee has the power of selection to determine not only whether a selection is proper, but also who is to take if no appointment is made. Specific class terms such as children, issue, heirs, and kin or next of kin are sufficiently definite. Family has been so construed, but terms like relatives have caused problems for the courts. Modern construction usually equates relatives with next of kin if no selection of other relatives is made by the trustee. Nature of beneficiaries' interests. Beneficiaries are generally viewed as equitable owners of the trust res, as well as the holders of rights against the trustee to have the trust carried out. A few states may still be contra, holding that the beneficiary has no interest in the property, but only personal rights of enforcement or a choice in action against the trustee. Number 1, extent of beneficiary's interest in trust. The interest may be for years, life, or infinite duration. It may be contingent or vested, possessory or non-possessory, or even subject to revocation, and the settlor may give preference to some beneficiaries over others. E. Trust purposes. Requirements of lawful and appropriate purposes. 1. A trust may not be created for a purpose that is illegal or contrary to public policy. Some statutes provide that a trust may be created for the purpose or any purpose for which a contract should be made, except for the special case of honorary trust. Super, a trust must be either private or charitable. Impermissible trust purposes. A trust or a provision therein may be challenged as invalid if it appears that the settlor was attempting to accomplish an objective that is illegal, requires the commission of a tortious or criminal act, or otherwise offends public policy. Examples of prohibited trust purposes include to perpetrate a fraud on creditors, to reward a person of committing an illegal or immoral act, or to unreasonably restrain marriage or to encourage divorce. Courts usually try to excise the legal purpose or condition and enforce the trust without it, unless this would defeat the overall purpose of the settlor in establishing this trust. 3. Related question of permissible duration. The law is concerned about the period of time during which the dead hand of a settlor may tie up property to restrict or impair the freedom of those beneficially interested in it. Private trusts designed to last indefinitely will run afoul of various rules of property law. A. Rules against perpetuities. This is the most significant limitation in most states. The common law rules, significantly modified or even abolished in a growing number of states, provides that to be valid, an interest must vest, if at all, no later than 21 years after some life in being at the time of creation of the interest. Number 1, requirements of vesting and certainty class gifts. An entire class gift is generally void if the interest of a single class member may vest beyond the period. 2, charitable trust. There is a partial exemption for charitable trust. The property's rights may validly shift from one charity to another beyond the period, but an interest may not shift from charitable to private or vice versa beyond the period of the rule. 3, effect of remoteness. The rule strikes down only the offending interest. The interest is generally carried out without the offending interest, unless the settlor's purpose would be defeated. Statutes in a significant number of states, often by adoption of a uniform act, reform the interest to comply with the rule. B. Statutory rule against suspension of power of alienation. Usually a transfer that violates the rule against perpetuity also violates the statutory rule against suspension of the power of alienation in a few states. Occasionally, a trust conveyance that does not violate the perpetuities period violates this rule. C. Rule against accumulations. Trust income may not be accumulated beyond the perpetuities period in most states, and in a few states the law is more restrictive. The rule is generally not applicable to charitable trusts. D. Trusts may continue beyond perpetuities period. Most states do not restrict trust to the perpetuities period if all interests are vested. However, after the period has expired, beneficiaries may join to terminate the trust and any restraints on the alienation cease. Number 3, creation of express trust. Methods of trust creation. The principal method of creating a trust are by 1. Declaration, 2. Transfer during lifetime or by will, 3. Exercise of power of appointment, and 4. Contract. B. Creation of inter vivos trust. Number 1. Requirement of effective present transfer or declaration. To create an inter vivos trust, there must be an effective and present transfer of the trust res. A declaration substitutes for a transfer. Present versus future transfer. A mere promise to hold or transfer property in trust in the future does not create a trust, at least in the absence of consideration. B. Delivery to trustee. A transfer requires adequate delivery of the trust res to the trustee. Chattels should be specifically passed to the trustee, or a deed, a writing stating the gift, should be delivered to her. In cases of real property, the settlor must effectively convey title to land. Where the settlor is also the trustee, a declaration of trust accompanied by segregation or identification of trust property substitutes for delivery. 1. Effective no trustee. Where there is no trustee for an inter vivos trust, the transfer requirement is not met. However, under special circumstances, courts may save the trust by holding the settlor or his successors constructive trustee until the court appoints a trustee. C. Notice to and acceptance by trustee. If an effective transfer has been made, a valid trust exists even if the trustee is not aware of it. Example, an effective delivery made to the trustee's agent who does not inform the trustee. The trustee's acceptance is presumed until the contrary is shown. After acceptance, the trustee is bound by the term of the trust and all fiduciary requirements. A trustee's acceptance usually relates back to the time the trust creation. 1. Disclaimer. The trust does not fail if the trustee disclaims before acceptance. A substitute trustee will be appointed. D. Notice to and acceptance by beneficiary. Notice to and an acceptance by beneficiary are not required for creation of a valid trust, as the beneficiary is presumed to accept. A trust may not. However, a trust may not, however, be forced upon a beneficiary who has the right to disclaim within a reasonable time. It is sometimes said that the beneficiary may not accept in part and disclaim in part, but this is probably only true where there are both benefits and burdens involved. The beneficiary may withdraw a renunciation of a trust interest where no prejudice to others is involved. 2. Registration of trust. In some of the states that have adopted the Uniform Probate Code UPC, trustees must register the trust with probate court at the principal place of administration. Failure to register does not invalidate the trust, but the trustee is subject to removal, denial of compensation, or surcharge by the court. Non-UPC jurisdiction do not require registration of inter vivos trust, but testamentary trusts are often subject to continuing probate court jurisdiction. Role of considerations. 3. Consideration is not necessary for a valid trust, and most trusts are gratuitous. However, a promise to create a trust in the future, even if in writing, cannot be enforced unless consideration was given for the promise. Where consideration is present, the trust may be enforced even though the requisite transfer was defective, as in the case of after acquired property. Statute of fraud. All trusts of personal property are valid in most states, but trust of land must be evidenced by a proper writing. Real or personal property. A. In determining whether the trust is of real or personal property, the key factor is the original status of the trust res. Equitable conversion doctrine generally is not applied. B. Type of writing required. If a writing is required, it need not be in the form of a deed of conveyance, but it must be reasonably complete and definite and must reasonably indicate essential terms of the trust, i.e., the res, beneficiaries, and the basic trust purposes. By whom the writing be signed. C. Typical procedures would have both the settlor and trustee sign the trust document. Otherwise, a required writing must be executed at or before time of transfer by a party who has the power to create the trust or by the grantee who thereafter receives the property. The signature of the beneficiary is not sufficient or required to create an enforceable trust. Part performance doctrine. D. Acts of part performance by the parties that tend to prove the existence of a trust may be sufficient to take the matter out of the statute of frauds. Generally, the beneficiary must have been allowed to take possession of the property, plus in many jurisdictions done some other act, such as uh, repair, payment of taxes, or the beneficiary must have been allowed beneficial use or otherwise been distributed fruits of the trust property. The trustee must be involved in or approve the fact relied upon to show the trustee's acknowledgement of the trust. Acts of part performance may also cure certain inactive or ineffective transfers. E. Effect of statute, bar to enforcement. An oral trust of real property is not void. It is merely unenforceable or unenforceable against the title holder. If the trustee is willing to form the trust, others have no right to object. However, transfer of legal title to a bona fide purchaser cuts off latent equities, i.e., a beneficiary's interest. F. Constructive trust remedy. If the trustee is not willing to perform and the trust is unenforceable under the statute of frauds, the intended beneficiaries or the grantor may have a constructive trust remedy. A constructive trust may be imposed if the conveyance was obtained by fraud, mistake, duress, due influence, abuse of confidential relationship, or in contemplation of transfers, death. Parole evidence is admissible to prove the trust intent and wrongful conduct. 1. No wrongful conduct. Where no fraud or special circumstances can be shown, the courts are split as to whether a constructive trust can be implied or imposed merely to prevent unjust enrichment. The position of most states allows the trustee to keep the land, but the modern trend is to favor imposition of a constructive trust. 5. Parole evidence rule, where a writing clearly establishes or clearly precludes a trust, parole evidence is inadmissible. If an instrument is ambiguous as to whether there is a trust, parole evidence is admissible. If the instrument is silent as to a trust, the majority and restatement position admits parole evidence to supplement an incomplete writing. C. Creation of testamentary trust. Requirements of Wills Act. A testamentary trust is one created by the will of a defendant or descendant. The will plus other evidence that satisfies the will's acts must provide all essential elements of a trust, although the court will appoint a trustee if necessary. In addition to the will itself and any codicils, the trust terms may be proved through the doctrines of facts of independent sufficiency, or significance and incorporation by reference. 2. Trust secrets, oral trust of outright bequest or devise, where a descendant's will devises property in reliance on a devisee's oral promise to hold property in trust for others. A secret trust arises. The oral trust agreement is unenforceable under the Wills Act, but may be voluntarily performed by the devisee trustee. A constructive trust remedy. If the devisee fails to perform, a constructive trust will be imposed in most states. No proof of fraud, undue influence, etc. is required. The majority would impose the trust in favor of the intended beneficiaries, but a minority of cases impose a constructive trust in favor of the descendants' estate or the decedent's estates. B. Distinguished semi-secret trust. There is a split of authority where the will indicates that the property is devised to someone in trust, but fails to specify a beneficiary. Many courts would find a resulting trust for the testator's heirs. Other courts would impose a constructive trust for the intended beneficiary. Breach of agreement by intestate heir. C. Secret trust principles also apply where the decedent died intestate, foregoing the property to make a will in reliance on a promise by an heir to hold property in trust for another. 3. Pour-over wills. A pour-over disposition is an attempted testamentary gift to a pre-existing trust, i.e., some or all assets of a decedent's estate are to be added to the corpus of a trust that was created during the decedent's lifetime. Validity questions may arise because the trust terms are set out in the trust instrument and are unlikely to meet the formalities of the Wills Act. Under appropriate circumstances, such provisions may be sustained by applying either the doctrine of unincorporation by reference or facts of independent significance. A. Modifiability of trust. Pour-overs are clearly acceptable in corporations by reference jurisdictions if an inter vivos trust was in existence at the time the will was executed and its terms are irrevocable and amendable. Modifiable trusts create greater problems. Some states find no problem if there was, in fact, no modification of the trust between the time the will was executed and the testator's death. Others invalidate if the pour-over language contains words of futurity. There is diversity of authority where the decedent modified the trust after executing the will. 1. Incorporation by reference. If there is a codicil to the will after the trust was modified, the original will is considered republished at the later date. Thus, the modified trust terms can be incorporated by reference. In the absence of republication, the courts are split as to whether the pour-over is completely defective or whether it has limited effect under the terms as they existed at time the will was executed. 2. Facts of independent significance. Application of this doctrine, because reference is not limited to pre-existing facts, allow the pour-over as intended by the testator, although some courts have rejected the application of this doctrine. The modern trend favors it. B. Pour-over to trust created by third party. Similar principles apply here as in the case of trust created by the testator. An additional problem arises if the third party has power to amend the trust and does so after the death of the testator. The modern application of the effects of independent significance doctrine allows this amendment to govern the poured assets and does the Uniform Testamentary Additions to Trust Act, UTATA, or UTATA, as revised. Uniform Testamentary Additions to Trust Act. Widespread legislation, mostly by enactment of UTATA, validates pour-overs to any pre-existing trust, evidenced by a writing, provided the trust is significantly described in the testator's will. Revocable inter vivos trust as will substitutes. Special problems. Is a revocable trust testamentary? Revocable trusts pose a special problem because the settlor often retains benefits along with the right to revoke. A court may find the trust illusory and hold that no trust was presently created. In such a case, the trust having failed, the asset becomes part of the whole of the would-be settlor's probate estate. The issue then becomes whether the trust document could serve as a testamentary instrument, which it likely cannot unless it was executed with testamentary formalities and testamentary intent. The courts often ask whether an interest really has passed to beneficiaries in the settler's lifetime and look for the settler's intent to create more than a mere agency. Modern authority recognizes that the settlor can validly create a non-testamentary trust even while retaining extensive powers or serving as trustee. There must, however, be an intention to create a trust, a specific trust res, and the trust must create some interest in some category of beneficiaries other than the settlor, although these may be future interests, vested or contingent, and may be revocable. Special types of revocable trust. Life insurance trust. A transfer of a life insurance policy to the trustee of a revocable or irrevocable trust is valid, with the policy itself being the trust res. Despite the similarity of revocable life insurance trust to testamentary dispositions, the courts have consistently upheld them, even with transfer of the policy, but with a mere even revocable designation of the trustee as payee of the policy proceeds. They are upheld on the basis that such trusts are no more testamentary than other revocable trusts, and either that the res is the trustee's rights as a beneficiary of the policy chose in action, or that the trust is created at the insurer's death by operation of contract. B. Toten's trust, savings trust, or tentative trust, where money is deposited in a bank or savings institution in the depositor's own name, quote, in trust for, end quote, another. Questions arise as to real trust intent or testamentary nature of the quote unquote trust. Most authorities presume that this creates a valid revocable trust. Revocation occurs to the extent the depositor writes a check or otherwise withdraws funds. These totem trusts differ from other trusts in that the depositor's creditors can reach the assets in most cases, and the trust terminates if the named beneficiary predeceases the depositor's settlor. On the depositor's death, funds left in the account belong to the beneficiary and are not part of the depositor's estate. Evidence including the depositor's statement and conduct is admissible to show the depositor's intent. 3. Revocable trust and substantive policies. A forced share of surviving spouse. Sometimes a settlor will transfer property into a revocable trust to attempt to avoid the surviving spouse's statutory forced share. The majority view at common law allows this, provided the trust is not illusory or a mere agency. Many states have adapted statutes, and a number have decisions allowing the surviving spouse to assert rights in the property, even if the trust is not illusory. Even in states that allow the use of a revocable trust to avoid the forced share, rights of dower or courtesy and community property rights cannot be circumvented. Taxation, creditors, and charitable restrictions. Under the Internal Revenue Code and most state laws, transfers of property into a revocable trust achieve no beneficial change in tax position. Absent legislation, property in a revocable trust is generally not reachable by creditors. The few statutes that now limit bequests to charity are generally held not to invalidate revocable inter vivos trust for charitable purposes. Transfer of beneficiary interest. 5. Alienability of beneficiaries' interest. A. 1. Right to transfer in general. Unless valid trust terms provide otherwise, beneficiaries' interests are freely alienable. Of course, the beneficiary can only assign such interest in the trust as she has. Thus, the transfer is not of the trust res, but of the beneficiary's equitable interest therein. Some states have statutes limiting alienability, and a few states retain common law doctrines limiting alienability of some non-vested future interests. 2. Form and manner of voluntary transfer. Generally, the equitable interests of a trust beneficiaries may be transferred voluntarily by the same method and formalities of non-trust interests in the same type of property. Consideration and notice to the trustee are not required. Some form of symbolic delivery may be required. 3. Rights as between successive assignees. If the beneficiary assigns the same interest to more than one assignee, the majority view is that the first in time prevails, subject to principles of estoppel. The minority view is that the first assignee to give notice to the trustee prevails. Creditors and other involuntary transfers. Subject to the trust term, such as spendthrift provisions, infra, the involuntary transfer of a beneficiary's interest is governed by the same rules as the legal interest. A. At death, a deceased beneficiary's interest is subject to the same rules of testate and intestate succession as a legal interest in like property. B. Creditor's remedy. The creditors of a beneficiary can reach her interest in the trust, but not the trust res, unless there are spendthrift provisions. The traditional remedy was a creditor's bill in equity. Statutes often allow direct execution on a beneficiary's interest. B. Restraints on alienation, spendthrift, and related trusts. In general, 1. Most states allow the beneficiary's interest to be conditioned or limited to prevent or impair transferability. 2. Spendthrift trust. Spendthrift trusts prevent voluntary or involuntary transfer of a beneficiary's interest in the trust. Thus, the beneficiary cannot sell or give away his rights, nor can his creditors levy on or attach such rights. These trusts are to protect the beneficiary from his own improvidence. They are valid in nearly all states. No special wording is required as long as the settlor intent is clear. The effect of spendthrift provision. Spendthrift provisions are generally given literal effect, except that some states require that limits on involuntary transfers could be coupled with limits on voluntary transfer. Some statutes also allow creditors to reach a percentage of the beneficiary's interest or any excess over the amount needed for support. 1. Effect of attempted transfer. And if the beneficiary tries to assign his interest, the assignee cannot enforce the assignment over the beneficiary's objection, i.e., the purported assignment is in effect revocable. 2. Creditors' rights. If there is a valid spendthrift provision, creditors are generally barred from reaching the beneficiary's interest in the trust. However, once monies are paid to the beneficiary from the trust, creditors can attach and execute thereon. A. Breaking through spendthrift restraints. Some classes of creditors may, quote unquote, break through spendthrift provisions, although states may differ on which creditors may, quote unquote, break through. The restatement lists 1. The federal or state government, such as tax claims. 2. A spouse or ex-spouse or child seeking support. 3. Providers of necessaries or necessaries. And 4. One who, quote unquote, preserves the interests of a beneficiary, such as attorney. Note, some or all of these creditors can, quote unquote, break through in most states. Spendthrift clause cannot protect settlers' retained interests. The owner of property cannot create a spendthrift trust from himself. Interests retained by the settler are reachable by his creditors. 1. Spouse beneficiary who elects against trusts. The fact that the beneficiary is the settler's surviving spouse and had the right to, but did not reject the testamentary trust and demand a share of the settler's estate does not make the spouse the settler so as to allow her creditors to reach her trust interest. C. Arguments for and against spendthrift trust. Against, there is a violation of the concept of symmetry of estates, i.e., there is no reason to treat equitable estates differently from legal estates, and public policy favors having property persons pay their creditors. 2. 4. The donee and his creditors, or the donee and his creditors, had no right to the property, which the settler was free to withhold. Therefore, the settler should have the right to dispose of her property with qualifications. 3. Discretionary trust. Such a trust gives the trustee discretion to make or withhold distributions of income or principal or both to or for one or more beneficiaries. Before the trustees exercise discretion to make payment to the beneficiary, it is generally held that the beneficiary's interest cannot be reached by creditors. If the trustee decides to pay, then the beneficiary's creditors are assignees, or assignees may reach the distributions. Number 4, protective trust. A protective trust ordinarily pays out income regularly, but upon attempted voluntary or involuntary alienation of the beneficiary's interest becomes a discretionary trust. These trusts are widely used in England and sometimes in American states that do not allow or significantly limit the spendthrift trust. 5. Support trust. What is sometimes called a support trust directs the trustee to make distributions as necessary for the education and maintenance of the beneficiary and to expend trust funds only for that purpose. Traditionally, in some states, the beneficiary's interest is neither assignable nor reachable by creditors. 6. Blended trust, where the trust is for the benefit of a group of persons and no member of the group has an interest separate and apart from the others. The interest is said to be blended with that of every other beneficiary. Such interests are not assignable and are unreachable by creditors. Number 7, distinctions questioned. Most trusts that grant trustees discretion regarding distributions contain standards usually related to support. Thus, the distinctions above are highly artificial and increasingly disfavored. Charitable trusts generally, or A, general nature and treatment of charitable trusts. 1. Creation and purpose of trust. A charitable trust is created in the same manner as a private trust by will, inter vivos transfer, or declaration, but is established by a purpose that the law regards as charitable, i.e., benefiting the public or a reasonably broad and appropriate segment thereof. 2. Charitable purposes. Purposes recognized as charitable include 1. Relief of poverty, 2. Advancement of knowledge or education, 3. Advancement of religion, and 4. Promotion of health, 5. Governmental or municipal purposes, and 6. Other purposes beneficial to the community. 3. Charitable trusts favored. Charitable trusts are favored by the law and receive special privileges. B. Requirement of public, not private benefit. Indefinite beneficiaries and the public benefit requirement. A charitable trust must be for the public benefit generally or for some members of a class of the public that is indefinite in number. A charitable trust, unlike a private trust, does not require definite designated beneficiaries. The state attorney general is usually authorized to enforce charitable trusts on behalf of the community. A co-trustee, successor trustee, or person having a special interest in the performance of the trust traditionally does not include the settlor, also has standing to enforce the trust. Effect of limited number of direct beneficiaries. A. Problems arise where a trust requires selection of a limited number of actual recipients or where the eligible group of potential recipients is limited. The modern view allows such trusts if the category from which the individuals are chosen is substantial in size and indefinite in membership, and if the benefit to the recipient is sufficiently within the general public's interest. The outmoded view held that the benefit had to be substantial, and where only a few persons were benefited, the substantiality test was not met. 2. Effect of trust having non-charitable co-beneficiaries, where the trust has both charitable and non-charitable purposes, or where the purposes are broader than those allowed for charitable trusts. It does not qualify as a charitable trust unless a separate amount share in or interest is provided for the charitable trust, i.e., a trust cannot have intermingled charitable and private purposes and qualify as a charitable trust. C. A charitable purpose defined. 1. Meaning of purpose and charitable. The purpose of a charitable trust or charitable portion must be exclusively charitable. The purpose for which the trust is created, the ultimate objection of the trust, is the controlling factor. Rather than the settlor's motive for establishing the trust, the term charitable does not include everything that a settlor may consider to be useful and worthwhile, but only what courts consider sufficiently desirable to the public. A trust to promote a cause that is illegal, immoral, irrational, or otherwise contrary to public policy will not be upheld as charitable. The purpose must be sufficiently well defined so that the court can determine 1. What the settlor intended, and 2. Whether the purpose is exclusively charitable. Trusts for charity are upheld, but terms like for benevolent purposes have sometimes been held to be unduly broad. However, modern tendency is to construe potentially broader terms as limited to charitable trust purposes. Particular charitable purposes, relief of poverty. This is a charitable purpose per se, a trust that significantly benefits indigenous and acceptable even if some non-indigenous may share, such as trust for parentless children. B. Education. A trust to improve the minds of indefinite members of the public is valid. This may be done through support of schools, museums, etc. Those receive the benefits of an educational trust need not be impoverished. Trusts that provide for the education of one's own descendants are not charitable, nor are trusts for the beneficial benefit of profit-making institutions. 1. Politics and change of law. The modern trend is to approve trusts for dissemination of particular political views, but a trust for the promotion of a particular political party is non-charitable. Trusts for general improvements of law are valid, but trusts to bring about particular changes in the law may or may not be. C. Religion. Maintenance and support of religion by providing for religious services, places of worship, salary of clergy, etc., are charitable purposes per se. Most states also allow trusts providing for masses to be said for the soul of the settler. The usual problem with religious trust is determining what constitutes a religion. Practically, any doctrine having numerous adherents in the community is acceptable, but certain beliefs, such as spiritualism, have sometimes been found to be irrational and of no widespread interest, and trust to promote atheism might be found to be non-religious, although they may be educational. D. Health. The cure of disease and promotion of health are charitable purposes per se. Indigents may benefit from such a trust, but such a trust may not be designed to enhance profit making. E. Governmental purposes. A trust for governmental or municipal purposes is charitable because there is governmental community interest in the functioning of the government. Trusts for prevention of suffering of indefinite groups of domestic or wild animals are valid, but trusts for maintenance of particular animals, such as my cat, are not unless as honorary trusts. Other charitable and non-charitable purposes. The general standard for charitable purposes applied subjectively by courts is a benefit to the public or indefinite members thereof. Perpetual care of graves is a questionable trust purpose, but is usually permitted by statute. It is not certain that trusts for the elderly, if not limited to poor persons, are of appropriate benefit to the community. Trusts to aid private social clubs or lodges for the preservation and display of the settlers' collection when not of general community interest, and for the erection of monuments to the settler have been held to be non-charitable. If a trust fails as a charitable trust, it may nevertheless qualify as a private trust if it meets private trust requirements regarding definiteness of beneficiaries, rule against perpetuities, etc., or possibly as an honorary trust if it is for an allowable honorary purpose. 4. Profit making or private purpose non-charitable. Although the trustee of a charitable trust may be a profit-making institution such as a bank, the purposes must not be for the benefit of a profit-making institution. If it is not objectionable if benefits for a profit-making institution are only incidental or trust funds for charitable purposes are segregated. A. Split interest trust. It is not objectionable if property is to be devoted to private purposes for one period of time and exclusively to charitable purposes for another. Split interest trusts are common in the form of charitable remainder trust and charitable lead trust. 5. Conditional gifts and charity. If conditions of gift might prevent the charitable interest in the property from being used exclusively for charitable purposes, the trust will not qualify as charitable. Exceptions. A condition that an activity supported by a trust be named after the settler, and a condition amount of gift, such as matching funds, do not affect the charitable status of the trust. D. Limitations on charitable trust. 1. Charitable limitations. Few, if any, states currently restrict dispositions that may be left by will to charity. Such statutes have generally limited amounts given or devices to charity if the will was made shortly before the testator's death. Such, such statutes were not generally applicable to inter vivos trusts, even if the trust instrument was executed shortly before the settler's death or the settler retained a life interest and the property and the power to revoke. Such legislation was, however, applicable to constructive trust that might be imposed upon property passing by will. Some states had similar legislation applying only to charitable corporations, charities, and the rules against perpetuities, too. The rule does not apply to the duration of charitable trust, but it does apply to the vesting of charitable gifts. Benefits of a charitable trust may shift from one charity to another even after expiration of the perpetuities period from, provided that the trust has vested in charity. 3. Constitutional limitations and charitable purposes. A state agency may not serve as trustee for a trust that furthers racial or other prohibited discrimination. State action may, in fact, be inherently characteristic of all charitable trusts today, although this question is unsettled. E. Modification of charitable trust. The Cypress Doctrine. 1. Nature and requirements of Cypress. Because a charitable trust may endure indefinitely, it sometimes outlives the purposes for which it was established. Courts may identify the trust to apply the trust in a manner approximating the settler's plan. To invoke the doctrine, 1. The settler's purpose must be fulfilled or frustrated. 2. Traditionally, or at least the settler must have had a general charitable intent. In such cases, a court will apply the trust benefit to a charitable purpose reasonably similar to that set forth by the settler. 2. Application of Cypress. Merely finding that a better purpose is available for the trust benefit is not sufficient to apply Cypress. At the very least, pursuit of the trust's original charitable purposes must be impractical. If A settlor has provided a valid express gift over in case the charitable purpose fails. The provision will be honored if it does not violate the rule against perpetuities. Because Cyprus traditionally is to be applied only where consistent with probable wishes of the settlor. It may not be invoked if the settlor really intended to benefit only a particular charity or charitable purpose and no other. Once a court decides to apply Cyprus, it must modify the trust in such a way as to appropriate or approximate as nearly as reasonable the settler's original purpose. Number 6, trust administration. General responsibilities and authorities of trustees. A. Number 1, introduction. The actions of trustees and beneficiaries are subject to legal rules governing the powers, duties, and rights of the parties of a trust. 2, functions, preservations, and productivity of trust res. A trustee has a fiduciary duty to work to preserve trust assets and to make them productive, and has a duty of impartiality in carrying out these functions. 3, the trust terms and sources of trustees' powers. A trustee must understand and follow the terms of a trust, and must understand the powers and limitations of the office. The trust instrument ordinarily expressly defines some powers of a trustee and may imply others. Trust law itself confers on a trustee the powers necessary or appropriate to carry out the trust. Although now many statutes and decisions imply essentially unlimited powers, court instructions may ascertain and or modify or clarify a trustee's power. Under certain circumstances, thank you. The terms and sources of trust powers. A trustee must understand and follow the terms of a trust and must understand the powers and limitations of the office. The trust instrument ordinarily expressly defines some powers of a trustee and may imply others. Trust laws itself confers on a trustee the powers necessary or appropriate to carry out the trust. Although now many statutes and decisions imply essentially unlimited powers, court instructions may ascertain or clarify a trustee's powers. Under certain circumstances, such as where they have the right to terminate the trust, the beneficiary's actions may affect a trustee's authority and obligations. Number 4, standards of fiduciary's conduct. A trustee's duties owed exclusively to the beneficiaries include 1, a duty to obey trust terms, 2, a duty to act with prudence by exercising care, skill, and caution, and 3, a duty of loyalty. The duty of loyalty extends to each beneficiary. Thus, a trustee is also required to act impartially. B. Powers of the trustee. 1. Meaning and nature of trustee powers. The term power refers to the authority, expressly or impliedly, conferred upon the trust or the trustee by trust provisions or by law, i.e., acts the trustee may perform. Authority to perform a particular act, however, does not remove the possibility of violating a duty, such as by exercising that authority negligently, unreasonably, or arbitrarily. 2. Powers generally. If a trustee has no powers but merely holds title to the res, the trust is passive. If it appears that the settlor intended to create more than a passive and no powers are stated in the trust instrument, powers appropriate, some have said necessary to carry out the trust purpose are implied by law. However, powers will not be implied if doing so would be contrary to the terms of the trust, except for court authorized deviation under certain circumstances. 3. What powers are implied as appropriate? Unless the trust instrument so forbids, the following powers are generally held to be implied: power to sell, lease, and incur reasonable management and other expenses, normally including the power to make improvements. Traditionally, there is no implied power to encumber, such as mortgage, trust assets, but this and other limits are increasingly being abandoned. The law does not confer an implied power to invade the trust corpus for the benefit of a life income beneficiary. Number 4, imperative versus discretionary powers. Most trust powers are discretionary, i.e., trustees is expected to use his judgment as to whether and how to exercise. If, however, the trustee is required to perform a particular act, the power is imperative or mandatory, and a court will order performance upon petition by the beneficiary. Courts limit review of discretionary powers to whether the trustee had abused its discretion. 5. Who may exercise trust powers? A. Co-trustees. Co-trustees have powers jointly unless the trust instrument or a statute states otherwise. Under traditional doctrine, co-trustees must act unanimously, but the modern trend allows 3 or more trustees to act by majority vote. Each co-trustee owes a duty of prudent participation and is liable to beneficiaries for his own improper or negligent acts and for failure to prevent or remedy acts of another co-trustee. If administration is stalled because of inability of co-trustees to agree, a court may direct the trustee action. B. Delegation of powers to third party agent or third person's agents. Under the modern view, a trustee has power to employ agents and servants to perform various acts and exercise management powers granted to him as long as delegation is consistent with general duties of care, skill, and caution. If power is delegable, a trustee has a duty of care in selecting, contracting with, and supervising or monitoring agents. C. Successors, trustees, and personal powers. Unless the trust instrument provides or circumstances clearly indicates otherwise, powers granted to a trustee are not personal to the particular trustee or originally named. Therefore, trust powers may be exercised by successor or substitute trustees. C. Duties of the trustee. In general, a trustee's conduct must conform to standards of law and to the requirements of the trust instrument. Questions to ask are whether the act was authorized, and if it was, whether performance was consistent with fiduciary standards and duties. 2. Duty to administer trust according to its terms. A trustee is under a duty to carry out the trust and to administer the trust estate in accordance with the terms of the trust and applicable law. A. Duty to perform personally. Question of delegation. A trustee may delegate ministerial functions. Discretionary functions may be delegated only when necessary under the traditional view or when reasonable and prudent under the circumstances under the traditional view or when reasonable and prudent under the circumstances under the modern view. Discretionary powers over distribution are non-delegable even under the modern view. No matter what type of function is delegated, the trustee must act with prudence, proper care, skill, and caution in the selection and monitoring of employees and in arranging the terms of the agency. A trustee may seek advice related to non-delegable duties, such as of lawyers or investment counselors, but must make decisions herself. 1. Liability for losses caused by agents. If a trustee delegates a non-delegable duty, she is absolutely liable, such as a guarantor, to the beneficiaries for the resulting loss. If the duty is delegable and she has used proper care, she is ordinarily not liable. The trustee is normally liable in her representative capacity, not personally, about absent fault to third parties for the agent's negligence, although ordinarily not the agent's dishonesty or the delegation was to an independent contractor. Duty with respect to other trustees. Each co-trustee is responsible for all functions in the administration of the entire trust, and each must use reasonable care to prevent a co-trustee from committing a breach of trust. A trustee is generally not liable for breaches of a predecessor trustee unless she knew or should have known of the breach and failed to redress it or negligently failed to rectify a breach. Duty under a directory provision. Whether the trustee is directed to follow instructions of a third party, such as a particular investment advisor, she has the duty to do so. However, a trustee must be watchful to avoid committing a breach of trust on improper instructions. 3. Duty of prudence, standard of care, skill, and caution. A trustee must exercise that degree of care, skill, and caution that is a reasonably prudent person would use in administering similar property for similar purposes, although some courts still use and purport to distinguish between a standard a prudent person would use in administering either her own property or the property of others. Trustees will with special skills. If a trustee holds herself out as holding special or superior skill, knowledge, or facilities, she is under a duty to exercise such advantages. A professional fiduciary, such as a bank, is generally held to higher standard than a lay trustee. Duty of loyalty to beneficiaries. A trustee has a duty of absolute loyalty to beneficiaries and must not engage in self-dealing or enter into conflict of interest situations. The exception involving unavoidable conflicts with loyalty to diverse beneficiaries is discussed as duty of impartiality, supra section 611. Transactions with trust estate. A beneficiary may not deal personally with trust estate assets. If she does, beneficiaries have the power to set aside such transactions. Transactions with beneficiary. Although such transactions are not flatly prohibited, a trustee must act with utmost fairness and openness in personal dealings with trust beneficiaries and has the burden of proving that such action was fair. Specific types of transactions. Number 1, loans. It is improper for a trustee to borrow from the trust estate. While the trustee is generally not permitted to lend her funds to the trust, the rule appears to be that she may do so only if there is a legitimate need for cash and other sources of money are not reasonably available. 2. Compensation from third party or third person. A trustee may not accept compensation from a third person for an act done in administering the trust unless, under appropriate circumstances, the compensation is paid for the trustee's additional services or services on the board of directors. Number 3, self-employment. A trustee ordinarily may not be compensated for services to the trust beyond those ordinarily required of a trustee. If services performed are not an aspect of the trustee's duties as trustee, it is often prohibited self-dealing for her to engage herself for the rendering of such services. In many states, the view is that a trustee with special skills, such as an attorney, is expected to use those special skills at least in routine circumstances, and that those services may be taken into account in determining reasonable compensation as trustee. D. Special problems of corporate trustees. A trustee may A trustee bank may not purchase its own shares, but may be allowed to retain such shares if expressly or impliedly authorized, such as specific bequests of those shares to the trust. Generally, a trust bank may not deposit trust funds in its own bank, although some states allow this if the prevailing rate of interest is paid. 1. Commingling investment of trust funds. Under modern authority, it is permissible for a trust of two or more trusts to pool assets or to purchase common investments. E. Exceptions to loyalty-based prohibitions. Self-dealing may be allowed if permitted by trust terms expressly or by clear implication, authorized by a court order or consented by all possible beneficiaries. Duty to collect and safeguard trust estate. 5. A trustee has a duty to take and keep control of trust property in accordance with trust terms. Thus, the trustee has an effective the trustee has an effective um, A trustee has a duty to take and keep control of trust property in accordance with trust terms. Thus, the trustee has an affirmative duty to collect and take possession of trust assets, to preserve the assets of the trust, such as inspect periodically, pay taxes, etc., and to defend the trust from attack, even by the settlor. The trust is entitled to indemnification The trustee is entitled to indemnification for expenses reasonably incurred in defending the trust. A. Duty to insure. A trustee has a duty to obtain insurance on trust assets, including liability insurance, when it is prudent to do so. Duty to segregate and identify earmark. A trustee must keep trust assets separate from her individual assets and earmark property so as to identify it as property of the particular trust estate. Exceptions. Corporate trustees are generally permitted to hold property of numerous trust estates and common funds for investment purposes. A. Liability in events of loss. Under the traditional rule, a trustee is absolutely liable for any loss that befalls trust property that is not property earmarked, but a modern trend is to hold a trustee responsible only for losses caused by failure to earmark. 7. Duty to account. A trustee owes a duty to keep records and render clear and accurate report with respect to the administration of their trust. 8. Duty to invest and make property productive. A trustee normally has a duty promptly and continuously to make trust property productive. Reasonable care and skill must be used to procure reasonable rate of yield for income beneficiaries, except as accounting techniques may compensate for inadequate or excessive income productivity. This duty includes the duty to rid the trust of unproductive, underproductive, or overproductive wasting assets, at least if such property would render the trust estate as a whole underproductive or overproductive of trust accounting income. A. Standards for trust investments. Under the traditional analysis of investments, the basic questions have been 1. Was the investment a proper type for trust holding? And 2. Was a particular investment selected with the requisite degree of care and skill? Trust instruments may specify that particular types of investments are authorized or prohibited. Statutory list of approved fiduciary investments still exist in a few states for a few purposes. 1. Prudent man rule. The prudent man rule over time came to be adopted by nearly all jurisdictions, but few, if any, still follow it today. The trustee was and is today held to a standard of both good faith and of care, skill, and caution in making investments. But under the prudent man rule, sub rules generally evolved to establish that certain categories of investments were or were not permissible for trust investments. Prudent investor rule. The third restatement and the Uniform Prudent Investor Act advanced a quite different and modernized rule for trust investment law. The so-called prudent investor principle now prevails in one form or another. In the trust law of all states, the prudent investor rule judges an investment not in isolation but as a part of the trust portfolio as a whole, with suitable levels of risk depending on the content, terms, and purposes of the particular trust and the circumstances of that trust and its beneficiaries. This rule gives increased emphasis to diversification and is much more flexible with respect to suitable levels of risk while preserving the duties of loyalty and attempting to clarify the duty of impartiality. Prudent delegation is authorized, and the rule also adds emphasis to the trustee's duty to be cost conscious in investing. B. Standards under rules of prudence. The trustee has a duty of impartiality and therefore must consider the interest of remainder beneficiaries as well as income beneficiaries. Property of investment is determined as of time of investment, and the trustee must dispose of investments that are or later become unsuitable to the trust. She will be personally liable for losses resulting from unreasonable retention even of original inception or assets. A trustee must also diversify investments. While the traditional view has emphasized the nature of each particular investment rather than the content and management of the trust fund as a whole, the modern theory calls for substantial diversification on all overall portfolio basis. The terms of a trust may alter the rules application to the particular trust. C. Specific types of trust investments. The modern rule asserts that no investment is per se or even presumptively imprudent, and investments, property, or propriety depends on its role in the trust portfolio and all of the trust holdings and circumstances at the time. 1. Common or commingled investment devices. The modern rule allows the creation and use of common pooled trust funds by corporate trustees and investment mortgage participations, mutual funds, real estate investment trust, or REITs, and the likes by all the trustees. D. Trustees, liability, and beneficiaries remedy. Standing to enforce trust. Usually only beneficiaries or co-trustees, successor trustees, or other fiduciaries on the beneficiary's behalf have standing to complain of a breach of trust and to surcharge the trustee for his actions. Beneficiaries remedies. 2. Equitable remedies for breach of trust include injunction, removal of trustee, and constructive trust. Where damages are sought, a trustee is personally liable to the trust estate or to the beneficiaries, i.e., is surcharged for any loss or depreciation in value of the trust estate and loss of income resulting from the breach of trust. Some cases in which the trustee has made an improper investment have compared income and corpus values of the trust with the value that would have resulted from improper investment, thus surcharging the trustee for loss in appreciation based on the performance of similar trust funds or some index deemed appropriate. Gains from improper investments cannot properly be offset against losses unless both arises from the same breach of trust. A trustee may be charged interest on amounts owing to the trust or beneficiaries because of the breach of trust. Any personal profits made by the trustee through a breach must be disgorged to beneficiaries. A. Relief from liability. Exculpatory clause. 1. If an exculpatory clause is included in a trust instrument, it will generally relieve the trustee of liability for negligence, but not for intentional breach of trust or gross negligence. Such clauses are narrowly construed. 2. Consent of beneficiaries. Where all beneficiaries consent to a trustee's actions, the trustee may be free from liability. In cases where not all beneficiaries consent, those who do not consent or who do consent are ordinarily stopped from pressing their claims. 3. Limitations period. Statutes of limitations, where applicable to equitable claims or the doctrine of laches, may bar actions if a beneficiary is dilatory in pursuing a claim. Trustees insolvency. In bankruptcy or other insolvency proceedings, questions of propriety or priority among beneficiaries may arise. Bankruptcy will discharge a trustee's liability, but not with respect to losses caused by fraud, embezzlement, or other intentional misappropriation. Generally, beneficiaries share pro rata in the available recovery against the insolvent trustee. 5. Good faith. A few cases have considered a trustee's reasonable and good faith effort to understand and perform her duties in mitigating recovery by the trust or its beneficiaries. Trustees' liabilities to third parties, contract liability. Traditionally, the trustee as principal rather than the trust estate is personally liable to the parties with whom the contract is his fiduciary capacity, unless liability is limited to the contract or a statute provides otherwise. A trustee who signs a negotiable instrument as trustee has properly negated personal liability, and the holder has an action against the trust estate, i.e., against the trustee only in his fiduciary capacity. Statutes in most states and a few decisions absent a breach of trust eliminate the personal liability of the trustee, and only the trust estate is liable. Indemnification. Under the traditional rule, a trustee has the right to or of indemnification against the trust estate, providing he has acted properly in making the contract. The right of indemnification includes the right to pay the liability directly from the trust funds, exoneration, or from his own funds, and then obtain reimbursement from the trust estate. A trustee may be indemnified for the reasonable cost of legal defense unless the suit arises out of breach of duty by the trustee. An insolvent trustee's indemnification rights may generally be reached by his creditors. Tort liability, number 2. Traditionally, a trustee is personally liable for torts committed by the trustee or his agents, with a right of indemnification from the trust estate if not personally at fault. It has held that trustees of charitable trusts were not personally liable for the acts of agents selected due with care. But the modern trend of authority, especially by statute, is again that absent personal fault on the part of the trustee, liability is only in the representative, i.e., fiduciary capacity. F. Duties and liabilities of beneficiaries. Beneficiaries' duties generally: 1. Unless the beneficiary is also a trustee, or unless the obligation is imposed by the trust instrument, the beneficiary owes no affirmative duties to co-beneficiaries or to trust estate. A. Breach of trust. However, a beneficiary does owe a duty to other beneficiaries not to participate in a breach of trust by the trustee or to profit, even innocently, from the trustee's breach. Mere consent is generally not considered to be participation in a breach of trust. An innocent beneficiary who profits from a breach of trust is liable only to the extent of the improper benefit, i.e., unjust enrichment, unless such beneficiary has changed position in good faith reliance. A beneficiary who participates in a breach is also liable for a damage to the trust estate or other beneficiaries. B. Indemnification. A beneficiary has no duty to indemnify a trustee unless he has contracted to do so. 2. Remedies against beneficiary. A beneficiary may be personally liable if he has benefited from or participated in a breach of trust. His beneficial interest in the trust is then subject to a lien or charge. Thus, except as inequitable, his benefits are suspended and impounded until the trust estate is restored and obligations of other beneficiaries have been paid. A. Creditors and assignees. Creditors and donnees of a beneficiary who has acted improperly are generally subordinated to the rights of the trust estate and other beneficiaries. Liabilities of third parties, generally and for breach of trust. Debts owed, where a third party is indebted to the trust estate, commits a tort with respect to the trust estate, or is in breach of contract with the trustee has a right to maintain suit against the third party. Under modern doctrine, a beneficiary may, by joining the trustee, sue the third party of the trustee, or if the trustee fails to pursue the claim. B. Breach of trust. Third party participation with trustee. A third party who participates with a trustee in a breach of trust may be liable to the beneficiaries of the third party if the third party had notice of the trustee's intent to misapply money or other property. 2. Third party's acquisition of trust property. If a transfer of property by the trustee to a third party involved a breach of trust by the trustee, donnie transferees, and non-bona fide purchasers take subject to the beneficiary's rights. Bona fide purchasers, i.e., purchasers who take for value without notice of breach, take good title free of other beneficial interests. Accounting for income and principles. Introduction. A. General nature of principal income. Problem. In the typical trust, interests are divided into income and remainder beneficiaries. In economically conflicting rights turn on whether receipts or expenditures are classified as income or principals. The problem is moot in cases of wholly indiscretionary trust. Two, sources and priority of accounting rules. The terms of a trust govern principal income accounting questions. For matters not covered by the trust instrument, all states have enacted principal income legislation, most by adopting a version of either the 1962 Revised Uniform Principal and Income Act or the 1997 Uniform Act. Trust accounting rules often differ from general accounting principles. Trust terms may give the trustee private rulemaking authority. Such discretion tends to be broadly construed by some courts and narrowly by others. The law is designed and a trustee's judgment is expected to reflect the fiduciary duty of impartiality. The 1997 Act grants the trustee the power of equitable adjustment to compensate a beneficiary whose interest suffers under the trustee's investment plan in a manner consistent with the duty of impartiality. Specific rules of trust principal income accounting. Allocation rules are default rules. One, where the trust instrument is silent, some specific rules are applied. Two, allocation of benefits, essentially receipts. The general rule is that ordinary receipts are trust income, while extraordinary receipts are trust capital. A, timing of receipts. An income beneficiary is generally entitled to net income from the date of creation of an inter vivos trust and from the date of the testator's death in the case of a testamentary trust. A frequent issue between successive beneficiaries is whether income received after the testator's or life beneficiary's death should be allocated on a basis of when received or when accrued. Under the common law, receipts were allocable to whomever was income beneficiary when the trustee received the income, exception, interest. By modern statutes, may apportion all income except dividends. Dividends, B. Ordinary cash dividends are treated as income. Extraordinary dividends, including stock dividends, are generally treated as principal, but still generate a split of authority. One, Massachusetts rule, modern statutory view. Stock dividends in stock of declaring corporation as well as stock splits are principal. Extraordinary cash dividends and stock dividends in stock of other companies are subject to refined rules and distinctions and are treated differently by various decisions and by the 1962 and 1997 acts. Mutual funds distributions are typically principal to the extent they represent capital gains and are income to the extent they represent ordinary dividends or interest. Two, Pennsylvania rule, one-time minority view. This was an apportionment rule under which extraordinary dividends were principal to the extent they reduced the book value of shares from what it was when the stock was acquired by the trust. Otherwise, they were income. The test was the intact value of the retained shares. Three, other corporate distributions. Other corporate distributions, such as stock rights and options, are allocated to principal. C. Allocation of proceeds from sale of trust assets. Generally, proceeds from a sale of trust assets are principal. A small minority may still follow the Pennsylvania rule of apportionment based on inact or intact value and dates of earnings for proceeds from a sale of corporate stock. In some states, if a trustee delays selling under product if a trustee delays selling under productive property which she had a duty to sell, she must allocate it as income and amount from proceeds based on a formula granting the income beneficiary to income beneficiary a portion reflecting what would have been received had the property been reasonably productive based on a average trust rate of return. This rule is also eliminated by many statutes. The treatment of wasting assets. Wasting assets are those depletable or perishable through use, such as timber, minerals, also depreciable assets. Often, where a wasting asset becomes part of a trust through a general testamentary bequest, such as all my estate, the trustee must amortize or sell the property and invest in permanent securities. In the case of a specifically devised wasting asset, an income beneficiary is usually entitled to all receipts. Legislation and cases vary and are in flux on these matters, even regarding retirement annuities. Bond premium and discount. In 1962, the 1962 Act forbids amortization except for non-interest bearing bonds. The second restatement allows but does not require amortization in the case of interest bearing bonds purchased at a premium. 3. Allocation of burdens, essentially expenditures. The general rule is that a trustee should pay ordinary current expenses out of income, while extraordinary expenses or those solely beneficial to remainder beneficiaries should generally be paid from the capital account. A. Losses from operation of business. Losses sustained in the operation of a business owned by the trust are charged to principal. B. Taxes, assessments. Ordinary property taxes are paid from income. Assessments for capital or permanent improvements are generally charged to principal, with the income account sometimes charged with interest, depreciation, or amortization. Upkeep. Current repairs and maintenance are charged to income. Insurance premiums are charged to income in some states, but apportioned in others. However, expenses incurred when a trust is initially established for the purpose of putting property in an income producing condition are charged to principal. Capital improvements are either apportioned or charged to principal and depreciated. D. Mortgage payments. The interest part of payments is charged to income and the principal portion of principal. Trustees' fees and administrative expenses. According to some cases, these are charged to income, but statutes and cases now tend to apportion. Depreciation reserves. There is a split of authority and the ability of direction in the trust instrument on whether a trustee must, or must not set up depreciation reserves to protect remainder beneficiaries. Absent a statute, some statutes require depreciation reserves in most instances, especially if the depreciable property was purchased by the trustee while others either forbid such reserve or leave it to the trustee's discretion. Number 8, modification and termination of trust. 1. When the settlor have power to revoke or modify. Traditionally, the settlor of an inter vivos trust has no power to revoke or modify unless such power is included in the terms of the trust. Exception, a totem trust. Many statutes, such as in California and increasingly under the Uniform Trust Code, are contra, making gratuitous trusts revocable unless expressly made irrevocable in the trust instrument. A. Distinguish rescission and reformation. Rescission or reformation of a trust traditionally is available on the same basis as for non-trust transfers, i.e., on proof of fraud, abuse of confidential relationship, etc. Recent restatements and the Uniform Trust Code allow rescission and reformation for mistake if shown by clear and convincing evidence. 2. Nature and terms of power to revoke or modify. Scope of retained power. A retained power to revoke implies a retained power to modify. An unrestricted power to modify includes the power to revoke. B. Exercise of retained power. A power to revoke or modify can be exercised only in accordance with the trust terms and by an intentional act of the settlor. The traditional view is that in the absence of an authorization by the trust terms, an inter vivos trust may not be revoked by settlor's will. Exception: Toten's trust, and also uniform and restatement trust law. 3. Rights and settlors, creditors, where settlor has power of revocation. The traditional majority view has been that a settlor's creditors cannot reach a revocable trust, but a growing number of states have state statutes or decisions allowing them to do so. Creditors can, however, reach a settlor's beneficial interest, such as a retained right to income. The settlor's trustee in bankruptcy can reach the asset of a revocable trust. B. Power granted to trustee, beneficiary, or third party to modify or to terminate. 1. Only as conferred by trust terms. A trustee has only such power to modify or terminate as provided in the trust instrument. This is also true of others whom such power may be granted. Number 2. Power of invasion. A power expressly granted to the trustee to distribute power to invade the principal may, as long as properly exercised, cause the trust to terminate. Judicial supervision. A trustee's or others' exercise of a discretionary power to modify, terminate, or distribute trust funds is subject to court review to prevent abuse. C. Power of beneficiaries to modify or to terminate. 1. When may all beneficiaries join or modify or terminate? There is a split of authority here. Nearly all states follow the Claflin doctrine. All beneficiaries, of all whom must be competent or perhaps properly represented, must join the request, and the proposed action must not defeat and does not take material purpose into account. 2. Consent of all beneficiaries. This has traditionally meant all potential beneficiaries, including those unborn and ascertained. Thus, in most situations, it is impossible to obtain the consent of all. There is a trend to modify this doctrine, allowing a guardian ad litem to be appointed for unborn or ascertained beneficiaries. This trend also affects the requirement that all beneficiaries be alive and competent. Material purpose of settlor. Because the Claflin doctrine requires that termination not defeat a material purpose of the settlor, courts will look to the language of the trust instrument, circumstances of its execution, and probably peril evidence to determine the settlor's purpose. Spendthrift provisions and usually trust provisions that last until a beneficiary reaches a stated age will, in most states, bar early termination and support trust or trust that is primarily discretionary as a benefit may suggest that the settlor have a protective purpose that would bar termination. Abandonment or removal of material purposes of the settlers consent to the request of all the beneficiaries. There is no material purpose barring termination under Claflin. However, the settlers' opposition does not prevent modification if a court finds that there is no material purpose barrier. A. Trustee's abandonment. If all beneficiaries request modification or termination and despite a material purpose, the trustee acquiesces, it has been held that the beneficiaries are stopped from later suing the trustee for premature distribution, and the settler probably lacks standing to do so. B. Purpose frustrated and impermissible. Where a beneficiary whose interest was protected dies or no longer holds an interest, that material purpose barrier ordinarily is deemed to be removed. Restraint upon freedom of beneficiaries to terminate ends by operation of law when the perpetuities period expires. Power of courts to modify or terminate. Judicial power to deviate from or modify administrative provisions. Under the traditional view, a court of equity may authorize the trustee to deviate from or modify the administrative terms of a trust where, due to change circumstances unforeseen by the settler, deviation is necessary, not merely convenient, but compliance with the original terms would defeat or substantially impair a trust purpose. By the modern view, it is sufficient that the deviation will further the purpose of the trust in the event of unforeseen circumstances. The mere fact that a trust instrument specifically forbids the act in question, e.g., prohibits sale of certain property, does not preclude deviation. Where a trustee should know of circumstances justifying deviation from the original terms of the trust, she may be liable if she fails to seek court approval to so deviate and blindly follows the trust terms. Two, power regarding distributive provisions. Under the traditional majority view, a court cannot alter any of the distributive provisions in a way that may result in taking from one beneficiary and giving to another. An increasing number of cases and statutes are contra. Acceleration of indefeasibly vested rights may be permitted in the rare situation where there are no other potential beneficiaries' interests to be affected. Some courts following the majority view have been able to find by construction that the power to invade is implied by the terms of the trust instrument. See also Cyprus for charitable trust. Super. E. Termination of trust by operation of law. Trusts will terminate by their own provisions if the period specified for the duration of the trust expires. Trusts will terminate by operation of law if 1. The trust purpose is fulfilled or prevented. 2. There have or has been a merger of legal and beneficial interests. Or 3. The trust estate has been destroyed or consumed. Trust arising of operation of law. Number 9, introduction. Number 1, general nature. Constructive and resulting trust are not based on any real expression of trust intent, but rather upon the operation of law implied by law or imposed by courts. Constructive trusts are devices imposed to remedy wrong or avoid unjust enrichment. Resulting trusts are reflections or implementation or reversionary interest. Number 2, statute of fraud not applicable. The statute of fraud does not apply to trusts arising by operation of law. 3, retroactivity, tracing, and accounting. Usually a decree establishing a constructive trust and occasionally a resulting trust is retroactive to the date the transferee acquired title. Duty to convey title. In most instances, resulting and constructive trusts are passive or dry trusts, and the trustee's sole duty is to convey title. Resulting trust. A resulting trust is equity's way of recognizing an equitable reversionary interest, i.e., an interest remaining in a transferor who made an incomplete or defective disposition of the beneficial ownership. A resulting trust may arise if 1. There is no express or implied intent as to some or all beneficial interests, such as excessive trust res for trust purposes, unanticipated circumstances for which no interest is expressed, or 2. An express trust is unenforceable, such as improper form prevents proof of beneficial interest, or 3. A trust fails in whole or in part for other reasons, such as illegality, impossibility, or disclaimer. Purchase money resulting trust, development and status doctrine. At early common law, status of doctrine. 1. At early common law, the courts adopted a strong presumption against the gift so that the use beneficial enjoyment was deemed to go to the person who paid the consideration. 2. Statement of doctrine under modern law, where the purchase money for a property is paid by one person at his direction. Title is transferred by the seller to another, and there is no close family relationship between payer and grantee. It is presumed that no gift was intended. There is intended a rebuttable presumption that the payer intended to grantee to hold title upon a resulting trust for the payer. The purchase money resulting trust has been abolished by statute in a minority of states. 3. Operation of purchase money resulting trust doctrine. A recital in a contract or deed that a particular person paid consideration is not conclusive. Parallel evidence is admissible to show the source and nature of consideration. Consideration may be in any form, even services or promises to pay, but payment of some or all of the purchase price after the transfer of title, partially upon credit, does not create a presumption of resulting trust. To invoke the purchase money resulting trust doctrine, the payer need not pay the entire price. Rebutting the presumption. The presumption is rebuttable by proof that no trust was intended. Such proof may include evidence that 1. Payments made were a loan to the transferee. 2. There was intent to make a gift. Or 3. There was an oral agreement to hold in trust for a third party. Or 4. Therefore was a close family relationship between the parties, which raises a counter presumption that a gift was intended. Constructive trust. Remedial devices, not really a trust. A constructive trust is not really a trust at all. It arises by operation of law as an equitable remedy to redress wrongful conduct or prevent unjust enrichment. It is imposed when an equity court is convinced that the person who acquired title to the property should not in equity be allowed to retain the property, but should convey it to another because the acquisition was through fraud, duress, mistake, etc., or the other holder will be unjustly enriched. 2. When oral trust unenforceable. A constructive trust is frequently applied when property was transferred with a trust intention that is unenforceable. If a transferee refuses to carry out an unenforceable oral trust, such as courts may in some circumstances impose a constructive trust. 3. As remedy for breach of fiduciary duty, a constructive trust may be imposed when property is obtained through breach of fiduciary duty owed to another, such as trustee absconds with trust funds and misuses money to buy land or stock. This is not limited to wrongdoing of trustees, but encompasses other fiduciaries, such as guardians. As remedy in non-trust situations, a constructive trust remedy is generally available to rectify wrongs and prevent unjust enrichment arising from fraud, mistake, etc. Effect of transfer to person to third person. If a wrongdoer sells the wrongfully obtained property to a bona fide purchaser, the wronged party may no longer have a constructive trust imposed upon that property. She may, however, have a constructive trust imposed upon the proceeds of the sale and profits in the hands of the wrongdoers. So that concludes the reading for today for this recording. I hope you guys appreciated this reading. When I return, we're going to pick up on Gilbert exam strategies, and I'll try to finish another chapter in this book. With that being said, thank you for listening in. If you'd like to make a donation again, you may do so by checking out the information to my Cash App or my Chime account in the description area of the video. I truly appreciate you all's time and your donations. Thank you again. Have a good one.